Good morning, everyone. Thank you for joining us today to talk about this seminar being COVID-19 labor and employment litigation learnings. My name is Andrew Kinley. I'm a commercial litigation associate here in Fredericton, New Brunswick with McInnes Cooper. Also do a fair amount of labor and employment law as well. And yeah, thank you for joining us today. Just one housekeeping note before we get too far into the seminar today is just want to say that we would kindly ask you to keep all your mics muted during the presentation, and then if you do have any questions, those can be put into the text field on the right side of your screen, and then we'll answer those at the end of the presentation.
So my name is Warshick. I'm an associate here in our Halifax office. Primarily, I do labor and employment law with a focus in the construction industry, but also do some litigation as those matters arise. We're here today to talk about COVID-19 labor and employment litigation. So we're going to be talking about some labor decisions. So those would be arbitrations arising out of grievances in a unionized context. And then primarily we'll be looking at employment decisions. What have we learned so far since this pandemic began 18 months ago, which is kind of incredible to think about. I gave another presentation yesterday on vaccination policies. And, you know, in my introduction, I had to pause for a second and reflect that on March 26th of 2020, I was packing up my laptop and files and heading home, perhaps with the naive idea that it would be a month at most until we were back in the office. And, you know, lo and behold, 2-3 months later, still hunched over my kitchen table on my laptop working from home. So a lot has changed in terms of how we work. Whether it's where we work, whether it's compensation, whether it's temporary layoffs. These changes to terms of employment in some instances have led to wrongful dismissal claims. And so what we've seen so far is you know, a slow trickle of decisions from the courts, particularly in relation to changes to employment terms that occurred very early on in the pandemic. Which we're going to talk about. We've also seen some early pandemic arbitration decisions around whether or not violating employer policies with regard to, for example, masking or not attending work when symptomatic, whether those amount to just cause. So those are the types of decisions that we're going to be looking at today, amongst others. And, you know, we hope what you'll take from this is that if you're an employer who has made some of these changes to your employees' employment terms, whether it's sending employees home to work from home, whether it was unilateral, you know, changes to compensation or canceling bonuses for a year, or, you know, terminating an employee for failing to abide by your policies on masking or vaccination or whatever it might be, that you take some of these lessons and might be able to apply them, you know, as you may eventually face a wrongful dismissal claim. Amongst other potential claims. So that's sort of the background to why we think this is important and what we hope you might be able to get out of it. Of course, if you are facing one of these claims, we would suggest you pick up the phone and give us a call. So let's head right into it then, Andrew. So the first lesson that we've learned from some of these early court decisions, so this is in the wrongful dismissal employment law sphere, some of the early decisions that we've seen have suggested that the impact of the pandemic on the job market as a whole is going to affect reasonable notice periods in wrongful dismissal cases. So, you know, as a bit of a background, if you are terminated, if your employment is terminated without cause, in a non-union context. So if your employment is terminated without cause, you are entitled to common law reasonable notice. And common law reasonable notice is a calculation that takes into account a number of factors. Now, if the employee in question has a written employment agreement with a clear, unambiguous termination provision that limits their entitlements and that waives entitlement to common law notice, then perhaps the employee won't have this entitlement. But otherwise, the employee at law has an entitlement to reasonable notice of termination. Reasonable notice of termination accounts for essentially the compensation the employee would have got during the period that they should have received notice for their termination. And compensation is taken broadly. There have been some decisions in the last couple of years that have affirmed that, that would include bonuses that they would have otherwise got. So looking at this calculation, the factors that the court looks at in determining what's a reasonable notice period include the employee's age. So typically, older employees are owed a little bit more notice. The court, takes notice of the fact that the older you are, the harder it is to, in some instances, retrain or take an entirely different career path. Length of service is one of the most important factors. How long you've been with the employer. It's expected that you've specialized in terms of your knowledge and operations. So that's taken into account. The type of employment is important. There's higher and more senior up employees typically are owed a little bit more notice. Highly specialized employees, so if you have a very technical position, you may be owed more notice at law than another employee might be. And then an important factor in the COVID context is availability of similar employment at similar terms. So is there another job like the one you've been working or like the employee's been working at a similar pay rate? And, with the broad effect of COVID on the marketplace, in some instances and in some industries, that's just not the case anymore. There isn't that availability of work. You can think of, for example, hospitality. That industry was severely harmed by the pandemic. And so those availability of that type of work has been diminished. So what we see then, just going on to some of the decisions that have come out so far, is what we see is that the courts are, slowly moving towards a real recognition of the effect of the pandemic on the availability of similar work for employees who have been wrongfully dismissed. And the first decision that came out, referring to the effects of the pandemic was Takis and Peninsula Employment. And so in that case, the dismissed employee was a business development manager for a human resources company. And he was dismissed early on in the pandemic, so March of 2020. And this was one of the very first decisions that was released that sort of referred to COVID-19 in this calculation of reasonable notice. And there, the court considered it as one of the elements, though not necessarily a dominant factor in awarding reasonable notice to the employee. So again, the court took notice that in March 2020, just as this employee was dismissed, the pandemic hit, and it was expected to be much more difficult to find a job. The next one was interesting, which is LaMontagne and J.L. Richards and Associates. And in that case, the employee in question was an accountant, and this decision came out a few months after Takis, which kind of stuck its toe into the water in terms of what the effect of COVID would be on the reasonable notice period. And this one, the court went a little bit more further, was a little bit more explicit in its consideration of the effect of the pandemic on the availability of similar work. And this seems to have impacted its total calculation in a more meaningful way. Interestingly, so as I mentioned, in that notice period, an employee is entitled to their total compensation. So, bonuses are included in there. When coming up with that total compensation figure, the court took notice that the employer had canceled its overtime, had instituted a policy against any overtime. So the employee wouldn't have been working overtime, earning a premium rate during that notice period. And then also took notice that the employer had canceled its bonus program for the year, or was expecting to pay out significantly less in bonuses because of its financial performance. And so these things also affected the total compensation package that was ultimately awarded to the employee for their wrongful dismissal. And then sort of the most bold of the decisions so far was the Craft and Firepower financial decision. It was a commissioned salesperson was dismissed. They were in an investment banking industry. There wasn't a lot of mergers and acquisitions going on in the early days of the pandemic. Of course, everyone remembers and might have looked at their stock portfolio and saw it heading south. So the court explicitly took notice that in this context, there wasn't going to be a lot of opportunity for the employee to find similar work. And looking at all of the other similar pre-pandemic cases, the court came up with a number, which was 9 months of notice. And then on top of that, added an additional month explicitly because of the effect of the pandemic. So it went through the full analysis, and then on top of that, added what it considered reasonable because of the pandemic. So this is probably the most bold or the decision that takes account of the pandemic the most so far. Closer to home, so those were 3 Ontario decisions. Closer to home, there was the Slater and Halifax Herald case, where the district manager and distribution coordinator was let go very early on in the pandemic. This was in March of 2020, about 2 weeks after the World Health Organization announced that there, or declared that there was a pandemic. In that case, which I think we're going to talk about a little bit later on, this was also a factor in coming up with the total award for the employee. Interestingly, though, and if we just go to the next slide, the courts in Ontario have drawn a fairly hard line on when the sort of COVID impact will be added into this assessment of reasonable notice. So in Yee and Hudson's Bay Company, and then Herreros and Glencore, which are 2 recent decisions as well, these employees were dismissed just prior to the effects of the pandemic really beginning. So in one, the employee was dismissed in August of 2019. The other was October of 2019. And so while the pandemic affected their job search, in the subsequent months, what the court said was that you have to take the state of the economy or the state of the availability of similar work at the time of termination. So it didn't take into account the effects of the pandemic on their reasonable notice entitlement. So that's what we've seen in terms of how this might affect reasonable notice. A question for our viewers today is, reasonable notice is a significant entitlement, which is why typically in written employment agreements, you seek to limit or waive that entitlement from employees. So the question is, do your employment contracts with your employees include a termination clause that sets out the notice period to which they're entitled in the event of a without cause termination? And there should be a poll coming up on your screen. Oh, and the best laid plans, as we continue to adjust from remote work, the polls are down. I'm informed. So, nonetheless, a question to take home anyway is to, one, consider whether or not you have written employment agreements and whether these have a termination provision in them. If not, your organization or business is susceptible to claims for common law reasonable notice. And then second, if you do have written employment agreements and they do have termination provisions, know that the law on reading termination provisions has changed quite a bit and significantly actually in the last year and a half. And so if you haven't reviewed those agreements recently, it's time to do so. Okay, so let's go on to our next lesson. So this is primarily arising out of the unionized context, and there's an easy explanation for that, which is that grievance arbitration and arbitration in general moves faster than the court system. And so we've seen some early indications in the arbitration context that breaches of employer policies around health and safety in the context of COVID, so policies around not attending work while sick, not attending work while awaiting test results, that breaches of these policies can amount to just cause for the purposes of termination. Now, arbitration decisions aren't binding on the courts. So if you're not in a unionized context, it's unclear what sway these types of early decisions will have if you had gone ahead and dismissed an employee for failing to follow one of your COVID-19 policies. But nonetheless, these are authorities that can be relied upon. The court may or may not accept the reasoning in them. Again, they're not binding, but they are helpful and they are a good signpost for the way that decision makers are leaning, which is generally speaking an emphasis on health and safety over individual rights and over the right to continued employment. So certainly in that balancing, it seems that the preference is towards the collective, which is reflected in other decisions that we've seen, including the travel ban decision out of Newfoundland, where essentially the safety of the collective trumped an individual's rights. So in that context, we've started to see more and more of these decisions being reported. The first one, and one of the earliest decisions out of the sort of pandemic situation, was in Garda Security. And in that case, there was an employee who attended work while they were supposed to have been isolating. So the employee had had some symptoms of COVID-19 and went to go get a test. And during that period, under the rules that were in place in time in the province of Ontario and under the employer's own policy, if you were awaiting test results, you were supposed to have been isolating. Nonetheless, the employee attended work during this period of isolation, and then it later turned out that the employee was positive. So the employee was terminated for cause for failing to follow the government mandate on isolation and for failing to follow the employer's policy on not attending work while isolating. And moreover, in particular in that case, the employee was not particularly honest throughout the process and did not really take any sort of blame for it or apologize for their behavior. So then there wasn't really any type of mitigation going on there that might have saved the employee's job in that context. The next decision is the Acon Industrial decision. And in that particular case, the employee had had symptoms of COVID-19 and was told explicitly by a manager not to come into work until they no longer had symptoms. During that period, the employee decided to attend work. At the particular site where the employee worked, there was a person at the gate who asked you this sort of standard questionnaire that we're all pretty used to now. Have you been out of the province? Have you been told to isolate? Do you have any symptoms, etc.? The employee lied, not disclosing their symptoms, and then also failed to inform the questioner at the gate that they'd also been told to stay home. And then that day they attended a meeting with a bunch of other staff, and it came out that they were supposed to have been home and they were terminated for cause, which was upheld as reasonable in the arbitration. And then another interesting case, again, out of the unionized context, this one in Alberta, it's a duty of fair representation case. Unionized, an employee was terminated, was dismissed for cause for attending work while they were supposed to have been isolating after traveling. So the employee went on their vacation. They flew down to the US. This was in May of 2020. They flew down to the US under the rules that were in place at the time. When they got back to Canada, they were supposed to isolate for 14 days. Instead, they attended work. It came out that they had attended work against the isolation policy that was in place at the time. And then it later came out that the employee actually did test positive. So the employee was terminated for cause. And the employee went to their union to grieve their dismissal, and the union refused to grieve the dismissal. And so then the employee went to the Alberta Labour Board on a duty of fair representation case, and the Alberta Labour Board determined that it was reasonable for the union to not represent the employee in this context. A couple of other just interesting cases to mention. A discipline case out of Vancouver. In this particular case, the Vancouver School District case, an employee who had been off on sick leave, they had some COVID symptoms, it's unclear whether or not they actually tested positive. They've been away on sick leave, and on their first day back to work, as a joke, they decided to cough on another employee. And so this resulted in a significant suspension for the employee, not a termination, but the arbitrator interestingly noted that the employee was lucky not to have been dismissed. So again, there is a real recognition in these cases of the severity and significance of COVID-19 and the importance of protecting health and safety in the workplace. The last one is an interesting one. It's from here in Nova Scotia. That's the Breton Ability Centre case. And in Breton Ability Centre, essentially the employer brought in a rule requiring that its employees, in particular their care workers, only work in one facility. So essentially, you had to choose your job, whether you worked in facility A or whether you worked in facility B. There would no longer be any crossover. And really, the impetus behind this was that the employer wanted to minimize the number of contact points in an average day, or having back and forth between employees, particularly where they worked with acutely vulnerable individuals. And so this was upheld as a reasonable policy requiring the employees to choose essentially one job or the other, which is an interesting, example, again, closer to home of the health and safety aspect taking precedence over other aspects in terms of employment freedoms.
So I guess our next polling question is, did your organization temporarily lay off any employees because of the COVID-19 pandemic? So watch your screen to answer. So I'm not seeing the results here, but I'm going to move on to our next subject here, which is the topic of temporary layoff. So
So it looks like
temporary.
it looks like 20% said yes, they recalled all of their employees, about 10% had laid some off and not recalled all of them, and 64% didn't lay off anyone.
Okay, no, that's good to hear. So the next topic we want to talk about is temporary layoffs. So this topic came up kind of at the beginning of COVID-19. A lot of employers were curious as to what they could do with employees and whether they were in a position to put them on a temporary layoff and how long those temporary layoffs could be. So we're now seeing these decisions get before the courts, and it's provided some further guidance on this subject. So obviously, most of the employment standards legislation across Canada contemplates that an employer has a statutory right to temporarily lay off an employee. However, traditionally a common law, a layoff has been treated as a constructive dismissal if it's for an indefinite or long-term period. And we're seeing the courts accept kind of that interpretation that if there has been a temporary layoff due to the COVID-19 pandemic, for example, a business had to lay off an employee because it wasn't able to provide them with work, or they weren't able to work from home or things like this, we're seeing that courts are finding that the employee was constructively dismissed and therefore there was a wrongful dismissal claim and the employee was entitled to an amount of reasonable notice. So we've seen this in decisions such as the Corma Inc. decision out of Ontario of this year. In that decision, the court found that, the economic reasons for laying off the employee, not being able to provide them with work and for the period of time was construed as a constructive dismissal. The British Columbia Supreme Court also reached that conclusion in the Catino case as well. And we're seeing that, in the Hogan decision, and then also a similar conclusion in the Catino case. So courts are not accepting that these, longer term layoffs where there's, a month, 2 months where an employee's not been able to recall to work, that they've been constructively dismissed and that they are able to sue for wrongful dismissal. So with this in mind, there's obviously this risk with it, and kind of our best advice going forward and trying to deal with these situations and trying to avoid constructive dismissal claims because of layoffs. Our suggestion is that it's best to include a temporary layoff clause. So we have a question for the polls now to ask for you as well. So watch your screens for that. And Alex, I might get you to read the results. I got a lot on my screens.
Absolutely. It looks like 11% don't have written employment agreements at all. 70% have written employment agreements but no temporary layoff provision, and then 20% have temporary layoff provision.
So yeah, this is a term kind of going forward that definitely should consider in putting in any standard written employment agreement to deal with situations and to avoid some of the uncertainty of dealing with a constructive dismissal claim because of layoff.
So similarly, temporary layoff is a unilateral, unless it's permitted by the employee's employment agreement, It's a unilateral change to the terms of employment, and when that occurs, that permits an employee their employment as though it had been dismissed. That's what a constructive dismissal is it's a dismissal, in other words. So once you're constructively dismissed as an employee, you have the same termination entitlements as though you have been handed a termination letter saying you're terminated without cause. So in terms of other types of changes to the terms of employment, suddenly having to work from home maybe could be a type of change that amounts to a constructive dismissal. But certainly the one that the courts look the most sternly upon are changes to compensation, being for the most part the most important term of employment from an employee's perspective. The courts are willing somewhat to accept minimal reductions in compensation. There are some cases out of Ontario that kind of set a threshold around 15%, expecting the employee to be able to accept that. But it is very much a contextual analysis. An employee who's making near the minimum wage, a 15% reduction in their salary hurts a lot more than the CEO, who might be making significantly more and who can absorb that type of reduction during a temporary period such as the pandemic. So one of these cases that we saw was the Kostecki decision, and in that case in particular, Ms. Kostecki, who was an engineer, her annual salary was typically around $155,000. In response to the pandemic, the employer brought in an across-the-board reduction in salaries of about 20%, canceled its bonus program for the year, and canceled its RRSP match for the year. And so when Ms. Kostecki accepted this as a constructive dismissal and filed her claim in wrongful dismissal, she was found to have been wrongfully dismissed and was awarded common law reasonable notice of termination. In looking at the constructive dismissal, the court found that this about 20%, she was still earning $130,000 on the year, but this 20% reduction in her salary amounted to a constructive dismissal. So that is giving us a bit of a guidepost for employers who brought in across the board salary reductions or canceled bonuses, which were otherwise expected annually by employees, or who might have canceled other benefits or RSP matches.
So the next lesson we want to talk about is the treatment of CERB and deducting CERB from a resulting wrongful dismissal award. So obviously CERB over the last couple of, or over the span of the last almost 2 years now, has been a hot topic with a lot of political discussion and so on. And I believe just a couple of weeks ago, the government kind of cut off CERB and has moved to different programs now to try to stimulate the economy or to assist people with finding new employment. But with that, with CERB, comes some interesting questions as to whether if an employee receives CERB, if those amounts should be deducted from a wrongful dismissal award. So as Alex was talking about earlier in the presentation, when an employee is dismissed, they're entitled to a reasonable amount of notice pursuant to the common law, and that is based on those 4 Bardolph factors. Once a court ascertains, what that amount is, then they need to consider whether there should be deductions for that. So with wrongful dismissal awards, there's an understanding that unemployment insurance isn't deducted because an employee has an obligation to repay that. It's not deducted from the wrongful dismissal award. But with CERB, things are still a little bit unsettled with this, and we can see courts trying to deal with this question on how to treat them in reducing or not reducing a wrongful dismissal award. So we've seen a number of cases already deal with this. So in Hogan, the British Columbia Supreme Court deducted an employee's CERB payments from the final wrongful dismissal amount because if it reasoned that if the court failed to deduct these CERB amounts, the employee would in effect be put in a better position than they otherwise would have been. So essentially it would be a double dip scenario. The notice period would compensate them for their loss of employment, and then CERB has also compensated them for their loss of employment. So for that reason, that amount should be deducted. And this approach was followed by the Saskatchewan Provincial Court in Abdon. Then some courts have also been struggling as well with how to treat CERB deductions given to the uncertainty of it. So it's understood with employment insurance that the employee has the obligation to repay the amounts that they receive for unemployment insurance. However, that's less clear with CERB. So with that, courts are dealing with it in a couple of different ways. For example, in the Slater decision, the Nova Scotia Superior Court dealt with it by accounting for, so they didn't directly deduct CERB, but what they did is based on the contingency that it was likely the employee was going to have to repay these amounts, it reduced 2 months from that. So the employee started with a 24-month notice award and they reduced 2 months based on the contingency that the employee was likely to have to repay. Similar approach was taken by the British Columbia Provincial Court in the Snyder decision. Then there's also two other approaches that have been used. So in the Andrews decision, the British Columbia Supreme Court didn't deduct CERB payments because it viewed that it was more than likely that the employee would have to repay CERB benefits. So they didn't deduct anything in that circumstance. And then the Iratakis decision is probably on the farthest end. So if we look back at the Hogan decision, the presumption is deduct CERB. With Iratakis, the decision is not to deduct CERB because the view of the court in that decision was that it would result in some degree of active unfairness because those were amounts for the employee to hold them over during the COVID-19 pandemic to find new employment. So we're still on the question of wrongful dismissal damages here with the topic of mitigation. So as I said, or as I kind of explained, with a wrongful dismissal award, you're looking at a common law amount of notice, a monetary sum to compensate that employee for the loss of employment. But with that, an employee has a duty to mitigate. So when they've been dismissed, they have an active obligation to go out and find alternative employment to compensate their loss of employment. They can't just sit at home and do nothing until they get paid out by an employer. So with this, obviously COVID-19 with different restrictions, making it difficult to go meet people for job interviews and so on, there's been some interpretation by the courts as to how employees are to mitigate their loss of employment during a global pandemic, which is interesting. So obviously an employee has to make reasonable efforts to find similar employment, doing the best they can to try to find an alternative employment. It's not a presumption of perfection, but they do have to make best efforts in trying to get to that. So we're seeing this reasoning coming out in the decision. The first one being the Moore decision of the British Columbia Supreme Court. And in that decision, the British Columbia Supreme Court deducted 3 months from an employee's wrongful dismissal award because it viewed that the employee had failed to mitigated their losses in the circumstances. So in that case, the employee had created a resume, had done some online searches for an identical job in the same industry, and had submitted a few online job applications. However, the court viewed that this was not reasonable efforts to try to mitigate their loss in the circumstances. Something more was required. They needed to submit more job applications, follow up on leads, correspond, emails. They really needed to put their best foot forward. It wasn't just enough to sit at home and wait out the storm. So the GOATS decision applied similar reasoning. In that decision, the British Columbia Supreme Court reduced the employee's reasonable notice period by 2 months because they found that speaking to people in the industry, registering for different job sites, and then just kind of perusing the internet for a new position was not sufficient mitigation. So the last lesson that we want to talk about today is frustration of contract. So similar to the topic of temporary layoffs, another question at the beginning of the pandemic when COVID-19 was brand new and there was a lot of uncertainties and questions, there still is, but we're starting to see these issues play before the courts. But one of them, kind of in line with the temporary layoff was whether an employment agreement could be frustrated due to the pandemic. Essentially, so to explain frustration, it's a general principle of contract law that holds that, if there's a fundamental change, a radical change in the agreement, if there's a fundamental change in the agreement, then the parties are absolved of their contractual obligations and do not have to perform them. Although it's a very high threshold, sometimes we see it in employment law with long-term disability cases, where, example, an employee's been on long-term disability for a number of years and not going to be able to come back to work. The employer there has pretty good grounds to say that the employment agreement is frustrated. However, the COVID-19 pandemic kind of presented a number of questions that weren't answered in the case law, but we're starting to see some answers to that. And the view of the courts are that the pandemic itself is not likely going to frustrate an employment agreement. So the Verrigan decision is a recent decision that just came out of the British Columbia Supreme Court. So in that case, the employer operated within the travel industry, travel agencies, things like this. And obviously, I think we can all agree that the travel industry was decimated by the pandemic. The employer terminated the employee after placing them on a temporary layoff. And from there, the employee commenced a claim for constructive and wrongful dismissal. And the employer alleged that the agreement had been frustrated due to the pandemic. The British Columbia Supreme Court did not accept that argument that the employment agreement was frustrated because although the pandemic itself made it more difficult for Ensemble Travel, the employer, to perform the agreement, it didn't make it impossible to do so. And the fact that the employer had kept some employees and also had hired some new employees after kind of the initial shock of the pandemic, this supported that the employment agreement was not frustrated between the parties and the employee was wrongfully dismissed. So closer to home in the Slater decision, frustration wasn't expressly put before the court. However, it was pleaded up until the day of trial. However, on the day of trial, the Herald decided to remove that claim or remove that defense. And what's interesting is obviously there was the removal of that defense. However, the court still decided to comment on it in its decision in a brief comment saying that in that case, the employee had worked there for 39 years, and the court basically said, you can't treat people like this with frustration. Basically, if frustration was accepted in that argument, an employee that had worked for the Herald for 39 years would be entitled to basically no amounts of money due to the frustration of the agreement. And the court cautioned that you can't treat people like that. So it's indicative of that courts are not going to accept frustration arguments for employment agreements due to COVID-19. So this kind of leads to our next practice tip or things to consider in implementing into your employment agreements. And one of these being that to avoid these types of frustration situations, it's probably best to include a force majeure clause into your employment agreement in order to deal with uncertainties like a global pandemic or a unforeseen circumstances like war or a global weather event that affects the employment agreement and makes it difficult to perform for the employer to perform the employment agreement. So this is something to consider in implementing into your employment agreements. So obviously we've covered a lot of ground today, but I think we're just at the tip of the iceberg here in these circumstances. We're starting to see some answers from the courts on some kind of unresolved questions that we had at the beginning of the pandemic with respect to labor and employment law and COVID-19. However, as you can see below there, there's still much below the iceberg that we haven't seen yet and is likely to come forward. Most of the decisions we discussed today are from trial level decisions. They're not from appeal court decisions yet. Some of the decisions may or may not be under appeal, and we may see some of these decisions overturned or some more clarity on these issues from higher level courts. And also one of the kind of major things that we're still waiting on or waiting to see is kind of an arbitrator's or a court's interpretation of a mandatory vaccination policy, and whether, you know, if there's a refusal to get vaccinated, if that's going to be cause for termination, and whether they can dismiss an employee in those circumstances. So we're still waiting on those questions, but given all the recent media on those subjects, I'm sure we'll see something relatively soon. So I think that concludes our presentation today, and going to move now over to some questions.
So feel free to type your questions into the chat here.
Okay, so we just had one question come in here. Any chance you can repeat the last point, the Nova Scotia example, health and safety job impact?
Not sure precisely which point.
Yeah.
Okay, if that individual wants to clarify, you can just send us another message in the question area there, and we can try to clarify that for you.
It looks like we have
Alex, you're the vaccination policy expert, so do you want to take that one?
Absolutely. Whether or not you're going to require vaccination or testing, I think it's going to begin with an analysis of your own workplace, and one of the sort of tools that we've been suggesting is an anonymous survey to your employees. If you haven't already introduced a vaccination policy, or you don't already have a COVID-19 safety policy in place, you know, we would hope you might have that by now. But if not, you know, the first step is to really determine whether or not it's going to be necessary, and what is necessary in that policy in the context of your workplace. You know, do you have employees who work really close together in you know, close quarters? Is your employment type the type of employment that can be done from home if somebody is refusing to vaccinate or refusing to test? There are all these types of questions that need to be asked to determine what is appropriate for your workplace. Certainly, I think that there is going to be more of a permissibility around testing regimes, in particular, if you're requiring testing to access the physical workspace or physical work site where employees are expected to work closely together. In terms of vaccination, we've got multiple articles on our website now about developing a vaccination policy. It is the type of policy that you should be consulting with a lawyer about, because regardless, these types of policies need to have some type of exception for those claiming a accommodation, or requesting accommodation rather, on the basis of human rights protected characteristics. You can think of, you know, religion or disability, for example. So rather than, I've given 2 full hour-long presentations on that in the last 2 weeks, so rather than continuing with that, feel free to reach out or check out our website with articles on the topic. It looks like we've got another question coming.
Looks like a workers' compensation question as to whether, if an employee, you know, contracts the virus at work, and if that entitles them to workers' compensation benefits. I think most, just speaking in kind of my knowledge from New Brunswick here, I don't know the policy itself, but I believe that WorkSafe New Brunswick has put out some policies to deal with that situation. Don't know them off the top of my head, but happy to look into them and give a more comprehensive answer there. Alex, I'm not sure what the approach is in Nova Scotia.
I mean, certainly there is sections on disease or occupational diseases. I think COVID, the question would really be whether or not you could ever trace it back to the workplace. You know, I'm thinking here in Nova Scotia with people going to restaurants and gyms and Wanderers games and Mooseheads games and taking public transit, whether or not you could be able to say that it was, you know, an illness or injury arising out of or in the course of employment. You know, I think if there was that touch point, you know, if there was knowledge that somebody had been in the workplace and was positive and was working closely with that person, you know, it might qualify as a workplace injury and then it would be subject to the WCB regime for those types of claims. So this is another vaccination question, happy to answer. What information do I request for proof of vaccination and how should it be stored and for how long? This is an interesting question. There are a few approaches that can be recommended. You know, you could first and foremost just send out the anonymous survey, which is probably the lowest level of intrusion into any employee's privacy. You know, this survey will be anonymous. We don't need to know who you are. We just want to see what our figures are in terms of vaccination. And, you know, you may end up, depending on the size of your total workforce, you may end up with 100% vaccination and then sort of your need to continue to develop policies or to request more information might be fairly low, assuming that, you know, you have trust in those answers. The next sort of level up is you could require an attestation as part of your policy. So you have the employee sign and attest on a form that you know, this is their true vaccination status, whether it is vaccination, whether they have been vaccinated or not been vaccinated. You know, you get them to sign a form. This is likely a good practice if you are required by some of your clients to you know, ensure that your employees are vaccinated. On top of that, you should probably be requesting their actual proof of vaccination. So if you have a client who says, you know, for entry to my work site, I need to know that your employees are vaccinated. If that's the case, you know, you don't want to be in a situation where you're making a negligent misrepresentation by saying, yes, we're only going to send you vaccinated employees, but you don't know for a fact the employees are vaccinated. So in that type of scenario, you know, you might have the employee sign an attestation, and then you might also have them provide their vaccination information. You know, whether it's that proof of vaccination that you can download from the Health Nova Scotia website, the same one that you use to enter a bar or restaurant here. In terms of storing the information, I mean, generally speaking, the best practices, if you're not a federally regulated employer who's subject to PIPEDA, which is like the federal privacy legislation, here in Nova Scotia, there is only legislation in terms of privacy that's incumbent on healthcare employers. Otherwise, most other private sector employers aren't subject to privacy legislation. Again, with the caveat, if you're federally regulated, you are. So there isn't a piece of legislation that really guides you in terms of what you can do with this information. There are some common law considerations about not sharing private details publicly. But really, you know, best practices, which we can take from the federal legislation, is only hold it as long as you need the information, limit access to it, be pretty clear with employees about what the information is going to be used for, who's going to have access to it, and then, if possible, seek consent for the collection of the information.
Just to chime in on that point, I would say that New Brunswick's law for privacy and storing this type of information is very similar to Nova Scotia. Some special rules for healthcare employers and things like that, but otherwise largely governed by the common law. And Alex's points kind of, you know, follow the best practices there. You know, this is kind of innately private health information, so, you know, make sure that it's, you know, in a safe location. only certain people can see it, and that kind of there's the express statement from the employer that this type of information is going to be destroyed when the pandemic ends, and is only really used for the purposes of understanding numbers as to who's vaccinated and not.
Got another question here. If someone was laid off as a result of COVID-19, is there a point where the employer no longer needs to recall the individual? This is a bit of a complex question. In the unionized context, you'd be subject to the provisions of the collective agreement, which likely deal with layoffs and recalls and the length of layoffs. So that would be very individualized to your workplace if this question was coming from a unionized employer. In the non-union context, temporary layoff is complicated as well because there are two factors to it. Essentially, at common law, did the temporary layoff amount to a constructive dismissal? Maybe the only way out of that is that the temporary layoff was agreed to in the employment agreement. So you had a provision that let you temporarily lay off an employee. The difficulty, though, is that there is still minimum employment standards legislation. So here in Nova Scotia Labor Standards Code, and that prescribes the total length of a layoff. And if you've exceeded that, in particular 6 consecutive days here in Nova Scotia, then you would be deemed to have already terminated the employee's employment, and they'd be entitled to notice of termination. Every province is a little bit different in terms of when a layoff becomes a termination. Some are much longer than Nova Scotia. But at this stage, if we're talking about a long-term layoff, you may have already dismissed the employee and owe them a notice of termination.
Yeah, I share all the same views as Alex there, and a similar approach here in New Brunswick. And there's, kind of a point in time as to recall, and it's kind of hard to draw the line as to exactly where that is. But if it's been a long time since the employee's been back to work, the recent cases are supporting that employee has been terminated both under the Employment Standards Act and under the common law through constructive dismissal. And at that point, they're able to can bring forward a claim for constructive dismissal, wrongful dismissal.
So it looks like we've had the same question again, and maybe we just didn't get to what was specifically being answered. But can you require vaccination or testing for all types of positions, temporary, part-time, seasonal, full-time? So the employment status of the employee doesn't have any bearing on the question of whether or not you should be requiring vaccination or testing, whether they're temporary, part-time, seasonal, occasional, full-time. That really doesn't enter into the equation. What we're talking about when we're talking about requiring vaccination or testing is really an occupational health and safety question, and then balancing that against your human rights obligations. So it is unrelated to their status. It's whether or not they're entering the workplace, going to be around people. There's the potential vector for infection, and whether or not that is a risk that you think you need to address through a vaccination policy or through masking or through regular testing. So it looks like that's it for questions, unless anyone, I think we've got 6 minutes. If anyone has anything left to ask, we'll hang on for a minute here. But then otherwise, thanks very much for your attendance today. We hope this has been helpful.
Thanks, everyone.